Alright, this opens with a quiet but serious pattern, control disguised as parenting concern. The father's side isn't just complaining about one decision, they're framing a repeated behavior. Unilateral medical scheduling becomes the centerpiece, not because of the appointment itself, but because of what it signals: exclusion. When one parent says, "I informed you, that's enough," shuts down co-parenting entirely. That's the real issue.
That are concerning, including one that was made March 21st of 26. Judge, I can tell you that the parties have had their session, at least one session with Joy Marlin, and I don't think they reached any specific agreements. I think there are some things that they discussed, and Ms. Marlin sent them with a list of ideas to talk to their attorneys about and see if those things could be ironed out. One of the issues in particular seems to revolve around mother's desire to change the physician, the primary care physician of the child. As this court knows, we went around and around with therapy trying to change the therapist for the child. We're having the same issue here. Mom wants to change the primary care doctor, unilaterally scheduled an appointment, told dad about it. When he asked about what's this doctor's appointment, what's the situation, her response was, "I'm not going to discuss it with you. I told you about the appointment, period." And that is reflected in the Our Family Wizard messages between the parties. I think mom wants the child to have a female primary care doctor. My client's not opposed to looking into that, to seeing if they can find some options, maybe a short list each could provide, and then see where we go with that or have the court decide. But it was a unilateral situation, and that's kind of what that's a situation that seems to be repeating itself. The child did start therapy with Megan Waltner as ordered by the court. The prior order of the court, specifically on the second page of it, required in the second paragraph both parents to reach out to the therapist to provide their information to the therapist's office and schedule an intake. This should be done as soon as possible. The contact information for the therapist was provided in the order. My client did his due diligence. He immediately went and provided his information to the therapist's office, tried to schedule around the child's school schedule because she has an IEP in two areas. She has an educational IEP, and then she also has a speech-related IEP. So they do provide services to her during the school day. He has tried in any appointment he's scheduled to schedule around that to eliminate as much as possible her needing to miss school. So he reached out to mom. He actually asked the therapist. The child has had 3 sessions at this point, so not enough to really give a progress report. But he did ask the therapist if mom had submitted her intake information yet. And she has not. And when he asked her about it, initially in Our Family Wizard, what you'll see is dad sending mom a message saying, "Hey, this therapist has pretty open availability on Saturday. If we scheduled a recurring day and time, would that work for you? Then when you have her, you could take her to therapy." So they would be equally participating. The response was, on February 26th, my client sent that message asking if that would work for her. And then also that, "Hey, the therapist said you still haven't turned your intake in." And on the same day, February 26th, mom responded and said, "I will not be discussing therapy with you any further. Thank you." Which obviously doesn't work for my client. It doesn't work for this child. They have to be able to communicate in order to manage the duties around this child. So again, on 3/27, so almost a month later, my client, after a therapy session, I believe that occurred on 3/26, said, "Hey, I asked the therapist again if your paperwork was done or your intake was completed." And they said no, but that you had completed, I believe on March 23rd, she completed a release of information form for her grandmother to access full information about therapy, but still had not submitted an intake or any documents or any additional information. So my client said, "I'm requesting again that you submit your portion of the intake, as it's important for the therapist to have your perspective as well." He offered to help her if there was something he could do to assist with her getting that in, and told her, "I'm trying to understand what's going on here. You tell the judge that Paisley's your top priority, but you just haven't complied with this order, and it concerns me given the history of the case and given the history of her behavior." He said, "Let me know if you're just refusing or if you're struggling some way, and I'll do what I can to help you." The response that he received to that indicated that mom works retail. She doesn't have much availability on Saturday or Sunday. And then went on to say, "You've stated she has openings on Saturday and she refused to reach out to me till Monday. So if she would like to call me with some times, I'm happy to work with it. My lawyer also sent her an email." She also told my client in a secondary message that same day, "I had tried to set my initial intake back in February, but Paisley was sick. My appointment time was at 1 p.m. back on the 14th, which was the only available time she had, and I was working. She had not reached out to me since, and this was the very same problem we had when I did mine, although it does state that only one person does an intake and when the parent has time to do so." So I think she was referencing in that message, one, that she was working during the initially scheduled time and she never reached back out to the therapy practice. But 2, I think she was referencing the prior domestic conciliation order. But even that order says that both parents are to reach out to the therapy office and have an intake with the therapist so that they get both sides of the perspective. And, he just learned, I think, for the first time that she appears to be working every Saturday and Sunday, which is concerning because if she's getting this child every other weekend and she's working Saturday and Sunday, we're not sure what's going on there. If the child's just hanging out with grandma or what the situation is. So we haven't made very much progress in the way of getting this child into therapy, although my client did go ahead and schedule some appointments regardless of mom not participating because he felt like, he couldn't wait any longer, essentially. So she has had 3 appointments to date, and she didn't have enough to really submit a report, but it's my client's understanding that one issue reported by the child is that mom's just not conversating with her a lot. We don't really know what the depths or details of that is. I think that will flush out later. But so there's not enough information just yet for a report. They don't have any solid agreements as far as the domestic conciliation. There are some things I think that my client would be amenable to that she's asking for. But I got an email on Friday afternoon with some proposals or what apparently mom thought they had agreed to in mediation. There is no memorandum of understanding yet, but I did receive a proposed agreed order about 7 o'clock this morning. I kind of went over that with my client. There are several things he's not agreeable with. So essentially where we are, judges, my client's concern and the history of this case will reflect that mom will do really, really good for a period of time. And she'll be involved. She'll be doing the parenting, going to school, doing all the things.
The father's side zooms out and connects everything into one narrative: instability. Not chaos, not crisis, instability. That's a powerful word in custody cases. He describes cycles, periods of engagement followed by withdrawal.
But then something happens and she just seems to fall off. And he's concerned that we're back at that point again where she's at the precipice, maybe with one foot over the edge, essentially, so to speak. She is taking this child, for example, she just took the child without telling dad, without providing any information or even telling dad the child was sick, has taken the child several times to an emergency room or to a minor emergency center without any conversation with dad, without, she's not sharing more information. She's sharing less information with dad, and she's unilaterally doing things that should be done together as the parents of the child. But additionally, I think we provided in our exhibits, there are some social media posts that mom has made that are very concerning. She has a history of mental instability in various areas, and there are some social media posts lately that she has made that are concerning, including one that was made March 21st of 26.
Judge, you asked for an update on like the mediation, and she's spouting all this stuff that I don't have notice about. I haven't asked my client about social media posts, and so I kind of object to this long narrative of just throwing my client under the bus with no notice or knowing that this is all what we were going to get into. I thought we were going to update you on mediation and probably schedule a trial date.
Well, Judge, it's in the exhibits that were provided to her office on Friday.
I don't think I got an email with exhibits.
Well, we sent an email with exhibits, and we have a sent email that shows the exhibits that were sent. So I'm not sure what the issue was there. I just pulled it up this morning to reprint them. In any event, we have made very minimal progress, I guess I would say, toward resolving the remainder of the issues. And I think it seems to my client like they're going backwards instead of forwards at this point. So it appears that we may just need to set a trial date.
Well, Ms. Gilmore, apparently this proposed memorandum of understanding had certain provisions that your client was agreeable with.
That's correct, Judge. There were some things in it that my client was amenable to, but there were several things that were not agreed to in mediation and that he's not amenable to because I just
such as?
Well, for example, mom wants to determine exactly, by name, by city, what school the child is going to attend for a certain period of time. That's not something that my client is ready to agree to at this point. Additionally, there were, mom wants to flip around some of the holidays, which he really did not agree to. He did agree with a Christmas break adjustment, but he did not agree with flipping the normal parenting weekend after that adjustment. Additionally, there was a request to make sure that only the parents could talk with medical providers and therapists. He's fine with that, so long as it works both ways. So it'd just be mom and dad being able to talk to the providers. However, he did want to be able to include his wife, which is Paley's stepmother, in like IEP meetings, things like that, because she does have input in the struggles that she might see with Paisley. And also she participates, in working with her on homework, things like that. That has never been an issue before. I think mom's never had an objection to that. So this objection seems to be a bit out of left field. Nevertheless, he's okay with that. In addition, there was a provision to change the child's primary care physician to a female doctor. She's been with the same PCP for 6 years. I think mom wants to change the doctor because of some trauma that she experienced when she was younger. And my client's not necessarily opposed to that, but he thinks that it should not just be mom picks the doctor and then the child goes. He also thinks that it should be minimally invasive with her school schedule. So if there are weekend or evening or late afternoon appointments, those should be taken. He does object to it being anywhere that grandmother or great grandmother of the child had previously worked. And he would like it to be somewhere not way out east so that both parties would have a substantial distance to drive. Additionally, I would say he would like to be able to continue scheduling the medical appointments because he's the one that's been doing that for the past 6 years. And he came to that role by virtue of mom's action or inaction. So he always tells her, he gives her notice of every appointment, any appointment time, date, what it's for. That is reflected in the OFW history between the parties. Typically, mom will acknowledge it and say thank you, but she rarely ever attends any of these appointments. So it's usually dad just taking the child to whatever the appointment may be. He would like to be able to make the medical decisions. Additionally, he was not in agreement with just turning over complete control for mom to make appointments like an annual well child visit. He thought the parents should both be able to be involved in that. The way that this was written would suggest that perhaps dad should not have as much involvement in there, and he's the one who is taking care of Paisley and her medical needs for majority of her life. Let's see. The parents notifying one another of all medical and therapy appointments and provide name and address of the providers. He's not opposed to that. He thinks that's a great idea. In fact, he's been doing that for some time. He's in agreement with that.
We see exactly why mediation failed. Control over future decisions. School choice, holidays, medical authority. These aren't minor disagreements. These are power points. Mom wants defined control. Dad resists locking himself into her decisions.
Let's see. The Halloween schedule. There were the holiday things he didn't agree to, but I think we might be able to resolve those issues with conversation between counsel. Summer break to continue. And then the parenting time during the school year was an impasse. Mediation was unable to resolve that issue. That's accurate. He absolutely agrees that that's correct.
All right, very well. Ms. Sir, your client's response to what's been presented?
Sure. With regards to the therapy, I will tell the court that my client has been in touch with Megan Waldner, the therapist's office. Megan insists that anytime she meets with the parent to do an intake, that the child also be present. My client only has every other weekend, and in all the messages that Lacey read to you, she didn't read one that Dad sent to my client, which said he absolutely will never let her pick up from school or let her schedule any therapy appointment on any time but her own. So that leaves her every other Saturday in order to do this intake with the child. My client did have an intake scheduled on February 14th, and then the minor child had strep throat and was sick. And so my client had to cancel that appointment. She called, left a message with the office. The office called her back a couple days later. And my client does work retail, so she can't always answer her cell phone when they call. They played phone tag some. She then was able to schedule one for this next week, but it's at 3:00 on a Monday. And so if Dad doesn't let my client pick up the child to take the child to this therapy intake, then she's very limited on her ability to comply with if Dad doesn't let her do that on his time and it has to fall on every other weekend. My client doesn't work every single Saturday and every single Sunday, but she works retail and her schedule does vary. So there are some Saturdays she works and then she couldn't do a therapy right in the middle of that. And so that is the reason why there's been some delay. And Ms. Gilmore is correct that I did send some information to the therapist to try to intervene and try to explain what the difficulty is at this point in time. So maybe with some clarity or some direction from the court that would allow her to participate in therapy or to do her intake on a day where it's not her regular parenting time day, that would help a lot. With regards to the medical scheduling, I mean, she doesn't attend a lot of the appointments that dad schedules because she doesn't get much notice and it doesn't always work with her schedule. He schedules them when it's convenient for him, but doesn't check my client's calendar. So she's at his mercy and only can go when she's able to go. So that is a problem, but it's not that she doesn't care. The talk in therapy around my client scheduling some of the well child and well woman checkups that are going to be happening is that this child now is hit puberty. She's started her period. And some of those things I think children are more comfortable with their moms handling versus dad. It's not that he couldn't do it, but I think with some comfort level, and that's kind of part of the reason why my client wants to transition to a female doctor. We did get an email from Joy Marlin that outlined what she thought the parties had agreed to. Apparently 3/4 of it, dad doesn't agree to. I put word for word what Joy said was agreed to in order and sent it to Ms. Gilmore. So I would say we are certainly at an impasse on the residency during the school year. I do think it's probably appropriate to schedule that for a trial. And then whatever ancillary issues she will agree to in that agreed order, we can file that, and anything that isn't agreed to, I guess, also needs to get passed to trial. I mean, we're there. My client has a very different version of events and other our family wizard messages that I think that the court needs to address, but I don't, and I just did double check my emails. The only email I got from Lacey Gilmore was asking about some records from a business record subpoena. So I did not get an email from her on Friday with exhibits. I can certainly talk to my client about those, but I think other than possibly addressing the issue that my client's having with the therapy, I think the rest of it probably needs to go to evidence would be my thought.
All
Judge,
right.
I think that some of the confusion about the exhibits may be that the email she would have received didn't come from me. It would have come from my assistant, would have come from legal assistant at pinnaclelaw316.com. Also, the emails or the OFW messages that we told the court, those are very recent messages in their entirety. What she's talking about is a message from many, many moons ago that was sent by my client to mom during a period of time where they were going around and around about therapy. He has never told her she's never going to be able to pick up the child for therapy when they're trying to jointly do therapy. But it's his understanding that the child does not have to be present for the parental intake, but for insurance purposes, that there are certain, like a child would have to be present for a percentage of the time in some situations. I would also tell the court that
Mom's side finally lays out their version, and it flips the script. Suddenly, Dad becomes the one restricting access. Therapy scheduling becomes a control issue from his end. This is classic litigation strategy. Same facts, opposite framing.
mom has not attended a medical appointment for this child with the exception of taking her to minor emergency in the last 3 years. And to say, well, she can only do this at 3 p.m., whatever time. My client had no idea that she'd even scheduled an intake. This is the first that we're hearing of it. The email from Joy Marlin was not a list of things that they had agreed to. In fact, what the email said is it's a list of ideas. I believe the parties got the same email because when counsel sent me an email, it had the email that Joy had sent to her client attached to it, sort of at the bottom. My client has shown me he received an identical email from Joy Marlin, and it does not say, here are the agreements, here's the memorandum of understanding. It says, here's the list of ideas from mediation. So I think maybe there's a misinterpretation or maybe a miscommunication about what an idea versus an agreement might be. And so my client, there were no actual agreements that I'm aware of that were made in mediation. I think there were conversations, there were discussions. My client agreed to be open-minded about those things, but I'm not aware that they made any agreements, and I've not seen a memorandum of understanding or even a draft memorandum of understanding regarding those things. My client has no issue with her picking up the child and taking the child to therapy. If that's an appointment, I think he welcomes her participation in therapy. And you can see by the messages, went out of his way to try and encourage her to get her intake done in order to make that happen. So it's disingenuous to suggest that somehow my client's trying to impede her access to therapy. What my client is trying to do is have the child miss as little school as possible. And she works retail. We have no idea what day she works, where she works. I think she works various different jobs, so I'm not sure what her schedule is on a regular basis. Perhaps if she posted it in our Family Wizard, that might be helpful. I don't know. But there was never an agreement of sorts in mediation.
All right. Ms. Sewer, you had mentioned that there was an intake appointment scheduled for the near future. When was that exactly?
They had availability for April 6th at 3. I think my client took that slot, but then I think now she's determined that she's scheduled to work until 6, so she's either going to need to get time off work or maybe move that intake to a different time. But if she can really do it during the school day, that opens it up a lot more. And I understand with trying to miss as little school as possible, it's just having to land on the every other weekend when is was making it very hard for her at first.
All right. What time does the child get released from school?
I believe she gets out at 4.
4:15, my client said.
All right. I would expect that with some advance notice that Mr. Hayes will accommodate the mother picking up the child from school in order to do the intake appointment on an evening. I realize how difficult it is to schedule with professionals. And if that's all that's available to her, then I would expect Mr. Hayes to accommodate it, but it would just be for purposes of the intake appointment and then return the child to Mr. Hayes. But that appointment obviously needs to get set up, and I don't want it to interfere with school. But she can pick her up from school and then go to the appointment. How far apart the school is from the therapist, I don't know.
And if it's right at the end of the day, but involves missing like an hour of school or as little as possible, is that okay?
Why? Why is that necessary?
I don't know that she has appointments beyond 4:15.
She does. I think she has 6 o'clock, 7 o'clock appointments.
Okay.
I will expect that the effort be made to try to schedule it where she's just doing the regular pickup from school at the end of the school day and then going to the therapy appointment, do the intake appointment with the child, return the child to Mr. Hayes. That's what the court contemplates. Further, I did want to give some direction to the parties regarding the primary care physician. Apparently, there's a long-term relationship here with the current primary care physician. Court will order that the parties remain with that primary care physician unless and until they agree on a different one. But it would need agreement of the parties. And I would ask Mr. Hayes to at least be open-minded. Apparently he is, to a transition to a new primary care physician, but I think it's one that the parties need to agree on. They need to be on the same page if they're going to change doctors. All right. Obviously, there appear to be some other issues that need to be resolved through an evidentiary hearing, and the court can go ahead and schedule that. But I want to ask Ms. Gilmore, how much more time do you need for preparation and/or further discovery?
Judge, I would ask for, if we set a trial date for 30 days, I think that would be sufficient.
Ms. Sewer, how much time do you believe is necessary to prepare and/or do additional discovery?
I don't have a need to issue discovery, so it would simply be putting together exhibits and printing off things. So, I mean, I would think a trial date, 30 days or sometime this summer would certainly be able to be met.
Okay, big difference between trial date and sometime this summer.
Well, I mean, April, May, I mean, I don't know if you have time 30 days from now. I mean, if you
I don't.
Then we may be looking at May-ish or June, which I consider to be summer. I guess it depends on how you define summer.
And this is where everything tightens up. The judge cuts through the noise and imposes structure. No more excuses. Schedule the intake. Make it work. Minimize school disruption. And cooperate. That's a reset. Then comes the key ruling. No doctor change without agreement. That shuts down unilateral decisions completely. The message is clear. This court is prioritizing joint authority, not individual preference. And finally, the inevitable trial date set. That's not just scheduling, that's escalation. When mediation fails and patterns conflict, the court moves to evidence. Now, everything said here will have to be proven. And that's where narratives either collapse or get validated under pressure.